me, I'll be. Thank you. So to give the context of which we are operating in, the Kenyan 2010 Constitution guarantees robust human rights protection with commitment to adhere to international human rights treaties, protocols, and conventions. However, colonial-era laws, specifically the Penal Code Section 162A, C, and 165, continue to criminalize adult consensual same-sex relations. This has led to legal ambiguity, further exacerbated by deep-seated societal prejudice, which have in consequence created a climate of impunity that emboldens law enforcement officers to perpetrate systemic human rights violations against the LGBTIQ Kenyan citizens. And so in this fundamental conflict that exists between our 2010 Kenyan Constitution values and the lived realities of our community fosters patterns of profound distrust, hinders LGBTIQ individuals to access justice, and leave violations largely undocumented and unaddressed, thus perpetrating impunity and marginalization of an already vulnerable population. So some of the realities that we have on the ground is that it's 679 cases of blackmail and extortion were documented since 2014, but this only represents 10% of actual cases. That means over 6,790 LGBTQ Kenyans have been exploited by the law enforcement officers. Nearly 1 in 3 transgender persons surveyed had been arbitrarily arrested with just existing while being a trans Kenyan. Only 29% of assaulted queer people report crimes to the police because, the mistrust between the law enforcement and the queer community. Some of the cases also that we've seen is blackmail and abuse of power and sexual violence in custody when arrested, with a large documentation that will be shared by our very able advocate who will be sharing the findings. So to address all this situation, INEND conducted this comprehensive research to identify the precise nature, prevalence, and impact of law enforcement officers' misconduct on diverse queer community across Kenya to inform targeted interventions and advocate for reforms toward human rights compliant policing. This research scope was in Mombasa, Kwale, Kilifi, Eldoret, Kisumu, and other areas with high reported incidences of law enforcement abuse against queer community. So I will be introducing our very able lead researcher advocate, Elizabeth Aroka Hasson, who will take us through what the research found and what it means for us to advocate and our pathway forward from this research. And I forgot to introduce myself. My name is Melody Njuki. I am the communications officer working with INEND and for INEND. Aroka, I invite you to share the research findings. Kindly share your screen.
All right. All right, just a minute. Can you see me? First and foremost.
Can't see you.
Can you see me now?
Not yet. Bado.
Oh, yeah.
Technology.
Oh, yeah. All right, I'm trying to share the screen. Can you see it from your end?
No.
Let's try that again. Sorry for that.
It's okay. Take your
I
time.
can see myself. How come you can't see me?
You can
All
see
right.
us. Can you
All
try
right,
sharing?
let's try that again.
Okay.
Mm,
Is it me who I can see your screen? Nelima, can you see Aroka's screen?
No, I can see her, but not the screen.
Oh, yeah. Oh, sorry. I did click share.
Oh,
Okay.
there you go.
All right. Now,
It's saying you, there you go. Select the screen.
let's just see.
Hmm. We can see your whole desktop.
Mm,
Now it's
Let's
you select what you need to share.
just give me 1 minute.
There you go.
Are you there?
Thank you. Go ahead. The floor is yours.
All right. So are you able to follow with me?
Yes.
All right. So good morning, everyone. It's a pleasure to be with you today to share these very important findings that will help us in terms of how to move forward to address the current situation that has been mentioned. We are having like a situation where there is a clear conflict between the law, the constitution, and the practice on the ground. So, as has been mentioned, my name is Elizabeth Aroka. I'm an advocate of 20 years. My principal place of practice is in Mombasa, where I run my own law firm. But with a strong human rights background, I also do consultancies for a number of organizations on different aspects, including research, investigations, training, and all. So, without any further ado, I'll just get on and start the presentation. Melody, how many minutes do I have?
You have roughly 20 minutes, if you can.
Oh,
Yes.
okay. So, in that case, I noted that Melody has given the introduction, the general aspect. So, I'll skip some slides. 20 minutes is short to summarize all the nice information that we have. But maybe I'll just move on to what the research was about. So, the research was a desktop design that involved the use of secondary data. So my team and I sourced for information from existing publicly accessible digital and documented materials. And we did not have any primary data collection or interviews or surveys. So this was basically an exercise whereby we looked at what was existing in terms of literature and reports. And I'm very grateful to the organizations that were able to share with us some of the findings and the reports that helped in terms of shaping the findings of this research. So these were the research questions. One were to assess the current legal framework and policies related to equality and non discrimination for LGBTQ persons in Kenya. Then the patterns and instances of discrimination and stigma faced by LGBTQ individuals, including by law enforcement officers in Kenya. Then the advocacy actions that can address the challenges and promote equality and non-discrimination, and also what the police, policymakers, and organization and other stakeholders can do to improve protections for LGBTQ individuals in Kenya. So because of time, can you allow me to just skip some of the slides? So for instance, on the issue of the review of the legal and policy frameworks, we collected and analyzed the digital copies of the Constitution, the various laws, those that protect, that are anti-discriminatory, and also those that perpetuate violence in one way or another. Then we also collected qualitative information from published reports, academic studies, and other sources of information to identify patterns of discrimination, particularly by the police against the LGBTQ community. We then synthesize the data and analyze the information using theme patterns to identify all those that I had mentioned with regard to the research question. So we had a bit of some limitation, of course, knowing that this was secondary analysis. We did not have the benefit of, for instance, doing one-on-one interviews with respondents to maybe understand some of the underlying issues or even to cross-verify. Then, of course, there's also underreporting and a lack of official data. There was also a bias in the available data, and of course, I've talked about the verification of information, because all we could do is rely on whatever reports that we could get hold of. So part of the ethical considerations was, of course, the issue of confidentiality and privacy. And we also sought to verify the credibility of the sources of information. We attributed the sources and also acknowledged the various limitations and the various approaches that we used in the analysis. So that also helped us in terms of moving it forward. So what were the findings? And I'm going to talk about these in different themes. One, the legal framework. Two, the institutional practices. Then three, the stakeholder analysis and the advocacy approaches that we can use to address all these different issues. So when it comes to the legal framework, what we realize is that we have a very progressive constitution, but we have one of the most progressive human rights framework and a Bill of Rights. And this being the supreme law of the land, all other laws must be in consonance with it. If not, then they become repugnant to the extent of that inconsistency. And this is emphasized by Article 21, 22, and all that. And we actually analyzed most of the articles. You will see we talked about the article that talks about privacy, non-discrimination, the rights of arrested person and all that. So all those are in the report. But today I'm just going to highlight. So for instance, Article 51(1) provides that persons who are detained, held in custody or in prisons under the law retain all the rights and fundamental freedoms in the Bill of Rights, except where such right is incompatible with the fact that the person is detained. So you find that although LGBTQ persons in Kenya are generally understood and advocated for as a minority group, the Constitution does not explicitly categorize or name them as such. So all these rights that you're talking about are subsumed in the rights of everyone else in the general population. So you find that the rights of LGBTQ are therefore protected in law by the Constitution's general provisions that guarantee human rights and freedoms to all persons resident in Kenya or that are subject to the law. And what we found is that this general protection at times is insufficient in practice, given the absence of targeted legal safeguards against discrimination based on sexual orientation and gender identity. And I'll be sharing like some of the court decisions that you've been able to see, and you realize even when it comes to that analysis or interpretation of the Constitution, there's a lot of bias that comes with that, in that you'll find a certain institution whereby the court will say, yes, this right, everyone is entitled to this right, so there was a violation in this particular aspect. But then you'll also find that certain cases where the court will come back and say, no, wait a minute, this right needs to be interrogated further. It needs to be looked into and all that. So we'll be looking at all that shortly. So one of the drawbacks articles is Article 45, which recognizes the family as the fundamental unit of the state. And this you find presents a specific challenge as it explicitly defines marriages between adults of opposite sex. So it directly impacts same-sex couples within the LGBTIQ community who may want to seek legal recognition for their relationships. So for instance, in the case of EG and 7 others, we find that the High Court acknowledged that the right to privacy under Article 31 does indeed extend and protect private consensual sexual conduct. However, the court refused to strike down the penal code, that was section 162 and 165. The bench held that the right to privacy, like all fundamental rights, is not absolute and is subject to limitations under Article 24 of the Constitution. And the court reasoned that the criminalization under the Penal Code was legitimately limited by other constitutional values, most notable Article 45(2), which defines the family and marriage as exclusively between persons of the opposite sex. And the court concluded that decriminalization would be contrary to the established notion of public interest and public morality, and the High Court effectively subordinated the individual right to privacy to a majoritarian view of social and moral values. This is just what I was talking about, whereby now the interpretation of the Constitution comes in, and you find that certain biases may come in, or one article may be used to limit other rights that have been guaranteed within the Constitution. And this then calls for us to see what actions then that need to be done to address this. So we have one of the progressive decisions. This is SC versus Director of Public Prosecution. This was an Eldoret case in which the court in 2025, the High Court in Eldoret affirmed the constitutional right of transgender persons in Kenya. And the case was brought by a transgender woman and an athlete following her arrest and subsequent human rights violations in 2019. And just a background to the case, you find that SC was arrested on a charge of personation, with the authorities claiming that she was falsely representing herself by leaving open as a woman. After her arrest, she was subjected to a series of humiliating and degrading acts when in custody. These included strip searches, non-consensual medical examination, genital inspection, laterals, all that were aimed to determining her gender, and also in inappropriate transfers between male and female prison facilities. Justice Nyakundi, in his ruling, held that the actions taken by the police, the prison department, and the hospital constituted severe violations of SC's fundamental constitutional rights. It specifically found that her rights to dignity, privacy, equality, non discrimination, and freedom from cruel and inhuman degrading treatment had been infringed. So this is an example whereby the court has come in and strongly interpreted the Constitution to ensure that the rights of the LGBTIQ community are protected. So some of the key things that came out of that decision was, one, there was the recognition of identity. The court declared that ACC is to be notably recognized as a transgender individual, and these affirm the right of transgender persons to determine their self-identified gender. Then it also gave a legislative mandate, and it ordered that the government was to initiate and table a transgender protection rights bill, or to amend the existing legislation to ensure the legal recognition and protection of transgender persons. I don't know how far this has gone. We probably may want to follow up to see how much compliance has been done with regard to the direction of the court. Then it also ordered for correctional facility reform so that we can have prisons, police stations, and any other places of incarceration accommodating transgender and intersex person, and so that we do not have the situation that we've had. In that case, SC was compensated 1 million in damages. I find that this decision is a significant judicial step, and it sets a precedent that compels Kenya to acknowledge and legislate protections against transgender persons. So this is one of those decisions that you look up and you're like, wow, there's actually a lot more that can be done in terms of protection of human rights of the LGBTQ. Then you also have the NGOs Coordination Board case versus Eric Gitari. This went all the way to the Supreme Court, and the court held that the freedom to association is one that everyone is entitled to. And of course, if we remember the first of the cases, is where the NGO Coordination Board had refused to register an organization, saying that no, you're going to come in to promote LGBTQ matters and all that. So the Supreme Court held that failure to register that organization was a breach of their right to association, and therefore that is again another landmark decision in terms of the recognition of the rights. I'll skip those. You'll be able to see the others because of time. I would have shared more on those. Then the other law that we were able to analyze was the Penal Code. Again, as I've said, all laws apply to everyone in Kenya without distinction. I have, however, just picked out some of them that come up with very salient features that we may need to look at further. So the Penal Code, as Melody had mentioned earlier on, we have Section 165 and 162 that have been used, and this is the one that talks about criminalizes canon on knowledge against the order of nature. So again, we've had this section of the law being used to criminalize same-sex acts, and these provisions have been used to justify the legal persecution of LGBTQ persons and the denial of their rights. And we've been able to cite like the case of EG and 7 others where the Attorney General and also the NGOs coordination board versus the hereditary and all that. So we've had a number of cases. I personally have handled a number of matters whereby this section of the law is being used by police officers to arrest, including arrests within private spaces whereby someone just comes in and gets into your house illegally, arrests 2 individuals and takes them to court. So this is one of the laws that is a great drawback. So we find the vagueness and the existence of this penal code provision creates a vital ground for abuse by police officers, and they frequently leverage these laws not for legitimate criminal prosecution, but they use it to arrest, harass, abuse, and blackmail members of the LGBTQ community. Because again, we realize even if you go back to the court records to find out how many of those cases of persons who've been charged with Section 165 and 162 go through the court process, most of them, in fact, most of them don't even, some of them do not make it to court, and most of them end up being withdrawn prematurely and all that. So most of the time, you find that there are all those informal cases in the community whereby that section of the law is being used to really frustrate the LGBTQ community. And we have a section whereby we've talked some of the practices that we've seen, and you find that, again, just using this law, you find that a number of LGBTQ persons are subjected to arbitrary arrest, to extortion, to physical assault, and sexual violence under the guise of enforcing this law on unnatural offenses and gross indecency. So this absence of explicit anti-discrimination laws continues to expose the LGBTQ community members, leaving them vulnerable to human rights violations. Then we also assess the Sexual Offences Act, and we find that the relevance for this is that we also have a number of sexual violence being meted against the LGBTQ community. And this is not confined only on violence as perpetrated by police officers, but also by other non-state actors. And this, you find, is precipitated by the deep-seated homophobia, transphobia, and the continued criminalization of same-sex conduct under the penal code. And this then creates a climate of impunity for offenders. So, for instance, you find that even if a case is reported under the Sexual Offences Act, again, the penal code will be cited to say that, by the way, you know what you're doing, you're coming to report a case of being raped. Yet you're a man, so what were you doing with that man and all that? And we've had instances whereby it can actually be used to make individuals not be able to pursue their cases under the Sexual Offences Act. And apart from the police officers, we find that at times this even comes up from the community and family members. And we've seen this happening, especially in situations whereby lesbians are targeted for corrective rape, in quotes, And this is targeted towards lesbian, bisexual, and trans women. And you find that some members of the community may want to change their sexual orientation and gender identity. So they will, if they come out and say that we are going to show you what it is. So we have all these cases, sexual offenses that are happening. So again, we have the Sexual Offences Act that is providing that framework for protection and response against sexual abuse. And it also provides the safeguards to facilitate the reporting and access to the various services, including medical and justice services against persons who have undergone sexual violence. So the law is there, but as I've said, there are all these drawbacks, whereby there's a lot of cross-referencing to the penal code and victimization. Then we also have the Computer Misuse and Cybercrimes Act, which the purpose of the act was to enable timely and effective detection, prevention, response, prosecution of Computer Cybercrimes Act, and facilitate international cooperation in dealing with computer and cybercrime matters. And we find that while the purpose was good to be able to address issues, to protect individuals from cyber crimes, we have had situations whereby it has been misapplied to target LGBTQ persons for expressing their sexual orientation or gender identity online. So, for instance, the police have been reported to use this as an avenue to increase harassment and violence through online technology, facilitated crimes, including doxing, cyberbullying, catfishing, unauthorized sharing of intimate messages and photographs, blackmail, and extortion. And we've had, there's a case, one of the cases that was has been shared in the report about a gentleman who was gay baited. So someone approaches you via an online platform, requests for a date, you show up for the date, once you realize that that is a police officer. So once you get to the venue, you're arrested or you're subjected to all those, the extortion and all those other vices that we have talked about. So this law, it is good, but you realize that it is being misused, not only by police officers, but also by the general population, whereby you find that information on LGBTQ persons may be shared online, and this can at times move from online violence to even offline violence. So there's a lot more that needs to be done so that you can be able to address this particular aspect. Because we find that at times an LGBTQ person who's a genuine victim of cyberbullying, blackmail, or unauthorized image sharing cannot safely report the crime because, again, they're afraid of how much information is out there and if they're going to be charged with other sections under the Act. Then you also have the Persons Deprived of Liberty Act 2014. And this act provides protections for persons detained in Kenya, including the rights of persons detained to be treated humanely and with dignity and to be subjected, not to be subjected to due process of the law, to be subjected to due process of the law. And it provides that various group of persons need to be held in separate cells, and the rights of intersex person to decide the sex of the person whom they want to be searched in the event that they have been arrested. We find that one of the drawbacks of the Act is that it fails to protect transgender persons or persons who are non-conforming gender. So emphasis has been given on the intersex persons, but you find that there's still that gap that we probably need to see how to go about it. It also talks about intrusive search or search around the concealed body cavity should be done in private and with due regard to personal safety and health, and that these searches should be carried with decency and dignity. So again, this is relevant because we've seen some of the violations that have happened, including the strip searches that have happened within the glare of the camera. Someone has been arrested, is in a police station, and some of the actions that are done are not in consonance with the dignity, decency of the person, or even health and safety. So this act also is in place to address that particular. And just back to the SC case, the Eldoret athletes case that I had talked about earlier, this Act was invoked severally in the submissions. And that was used to challenge the police handling, arguing that the authorities failed to adhere to the statutory requirements designed to safeguard the individual from arbitrary or degrading treatment. And the court went ahead and assessed the police's action against the PDLA standards for detention and custody. And it went on to hold that the proceeding against the athlete should be halted for being contrary to the fair human treatment. Then we have the Prevention Against Torture, and this one prohibits inhuman, cruel, degrading treatment or punishment of individuals. More so, and in the context of police, it's during the arrest, incarceration, during the police, and all that. And a case in point is COL and another versus the resident magistrate Kwale, whereby the police, after arresting two suspected gay men over suspected same-sex conduct, they subjected them to forced annual examination and non-consensual medical tests, including HIV testing. The matter was later taken to court, and the Court of Appeal held in favor, saying that the rights guaranteed in the Constitution, particularly the protection against torture, as the substantive domestic law emphasizes and criminalizes, so as to prevent torture and all those different acts. So this again is an act that has been used by the court to emphasize on the importance of ensuring that LGBTQ persons, even at the point of arrest, continue to be treated within the given constitutional standards and safeguards. So we have more laws in the report. You'll be able to see that once that is shared. So the other thing that we're able to look at were the patterns of abuse by the police. And we had a number of things that came up. And one of them was arbitrary arrests. And you find that reports from organizations like the National Transgender Advocacy, Human Rights Watch, Legal consistently document this concerning trend. For instance, the NTAN in 2020 revealed that of the 119 transgender and intersex persons surveyed, nearly a third had been arbitrarily arrested and incarcerated. So then this means this is a big problem in terms of being arbitrarily arrested. And we've been able to identify what then is an arbitrary arrest. And this is the seizure and detention of an individual by state authorities without a legally justifiable cause, without a proper procedure or due process. So you find that someone is taken into custody without a valid warrant, without having committed a recognizable offense, or for discriminatory reasons not supported by law. And you find that this practice undermines the rule of law and violates the fundamental human rights, including the right to liberty and security of the persons. Then extortion also came up, and these we've defined as the practice of obtaining something, especially money, through force or threats. And in the context of police conduct against LGBTQ persons, it involves officers or other perpetrators demanding money, sexual favors, or other valuables under the threat of arrest, physical harm, or public exposure, or other adverse consequences. So this came out, and the scale of this is immense. And as had been mentioned earlier on, Legal Act has formally dealt with 679 cases of blackmail and extortion since 2014. But anecdotal evidence from local organizations suggests that thousands more of cases go unreported. So probably this is an area that we really need to go back and do further research to find out what is the exact number of cases of extortion that are in the community that have happened, but have not been reported because of various reasons. Then there have also been cases of detention inconsistent with gender identity. This goes back to the Persons Deprived of Liberty Act 2014 that I've talked about, whereby the Act clearly states that males should be held separately, females should be held separately, intersex persons separately, children should be held separately from adults, and so far. So we still have reports of people being detained when inconsistent with their gender identity, and something that needs to be looked at. And as I said in the earlier case, the High Court had said that transgender persons, they need to come up with policy guidelines, including on the issues of incarceration, so that we can have specific holding cells. I remember a case whereby, due to lack of facilities in Shimolatewa, one transgender person that was defending in a criminal matter was then transferred to a psychiatric unit within the prison facility. So this tells you how much of a need there is on the ground. Then again, there's long detention with incommunicado. So someone is arrested. The Constitution is very clear at the point of arrest. One is supposed to be informed of the reason for the arrest. They need to be given a phone to call someone, whether it's their lawyer or their friend or someone, just to inform them where they are. This again is not happening. So we're having many LGBTQ persons being arrested and there's no communication. And at times they're even held longer than the constitutional 24 hours and just being let go as it is. Then cases of sexual violence in custody have also been reported by various reports. And just to quote one report by NGLHRC Legal Act, the respondent stated that while taking us into the cell, the police was signaling to the other detainees that they were bringing people who pretend to be ladies. When we got into the cell, the other detainees started slapping us. They threatened us with a broken mirror, saying that they wanted to do it with us in the way LGBTI people do it. We were forced to do it at night. It was a very long night. So again, this goes into underscore situations whereby the police officers themselves may be the ones who are meeting the violence, or they are permitting the violence to happen within their watch when people have been arrested and they are in their custody. Then another act that came up was the use of violence to extract confessions. And this is particularly in relation to Section 162 and 165 of the Penal Code. Under 2021 submission by the UN Human Rights Committee by the Advocates for Human Rights stated that police threaten LGBTQ persons and use violence to extract confessions. So this, again, is a key concern that needs to be looked into. Then we still have post-annual examinations, despite the Court of Appeal judgment in 2018 declaring post-annual examinations unconstitutional, unreasonable, and a violation of Article 19.2 of the Constitution. But despite this, we realize that this invasive and humiliating practice still persists, and police, often in conjunction with medical personnel, submit individuals suspected of same-sex conduct to these examinations, purportedly as evidence for offenses under Section 162 of the Penal Code. And one interesting thing that we noted is that currently, in order to beat this decision by the Court of Appeal, what is happening when individuals who are to be charged under 162 are arrested, the police are making them sign consent forms when already under police custody. So they come with a form, please write here that I've consented for a medical examination to be conducted upon me. Then once that has been signed, then they are presented to a health facility and all the annual examination, the HIV tests and all that are done. And these reports are then now being brought to court as evidence to support the charges that have been preferred against them. So again, this talks of a tactic evasion where the court ban is being circumvented by compelling these detainees. Because even if the accused person or the person who's under arrest has signed the consent form, what are the circumstances under which they're signing the consent form? They are under arrest. So it means there's a lot of undue influence, coercion, and duress that makes it so that the consent is not a voluntary consent. So these are the other areas that we need to look at closely. Then we also noted that there is a lot of harassment of LGBTQ activists and human rights defendants. And this was documented, whereby there have been crackdowns on LGBT rights organization, arrests of staff, and even seizing of the equipment. I remember one time when one of the organizations in Mombasa, they're on their weekend, I told the police have broken into the office and that they are seizing computers and documentation and all that. So this too has been documented, and there's been a lot of harassment, intimidation, arbitrary arrest, and even physical violence. And this effectively stifles the critical work that we as human rights defenders are doing to be able to propagate for the rights of LGBTQ persons. Then lastly, it was also reported that there is a failure by the police to protect LGBTQ persons and to investigate crimes whenever that is reported to them. So, for instance, the Human Rights Watch, I think there's a more recent report, highlighted that police often ignore cases of crimes targeting LGBTQ individuals. It's noted that victims of physical attacks and harassment have reported that police often take no discernible action when these incidents are brought to their attention. And even when they attempt to report violence, they risk further abuse, verbal harassment, or even arrest from police officers. So we have organizations that are able to share with us some of the reports and studies that they've done so as to give us the data on this particular aspect. And for instance, just like no other study report gave an account of Winnie, a lesbian who had a business in the market. And she reported that one day in 29, she was away from work and left one of her children to take care of her business. A group of people destroyed the stall and injured the child, saying that the LGBTI customers were affecting other businesses. When she went to report the crime, the police told her to look for the attackers and bring them to the police station to be arrested. Similar reports have been reported, including in cases of death. You find that, for instance, the Sheila Lumumba case, the family members of Sheila, a non-binary lesbian who was sexually assaulted and brutally murdered, in Nyeri, stated that the police did not do anything. We had to start our own investigation. So you can imagine this is a situation whereby members have lost their loved one, and you will expect the wheels of justice to start churning, but nothing is happening. So it's a family that has had to start their own investigations. Similar with the Edwin Chiloba case in 2023, after Edwin Chiloba, a prominent LGBTQ activist, was found in a metal box murdered, it took days before police confirmed that the killing was being treated seriously, with activists fearing a cover-up. The delayed police action was seen as a symbolic of the system's disregard for queer lives. So this systematic failure and pervasive failure to conduct prompt, thorough, independent investigations into allegations of hate crimes and gender-based violence against LGBTQ persons raise concerns of institutional homophobia and transphobia within the police service and other institutions. Further, police misconduct, as evidenced by the high numbers of complaints recorded by organizations like Legal Act, often goes unpunished or is not adequately investigating, further perpetuating the cycle of impunity. So we find that we have institutions that have been put in place. IPOA, the Ministry of Interior Security, KNCHR, being constitutional bodies, they are mandated to investigate human rights abuses and monitor police conduct. The effectiveness is often hampered by systemic challenges, including resistance within the police service and the inherent ambiguities in the legal framework. So what was the conclusion? So the desk review conclusively demonstrated that the human rights of the LGBTQ community plus community in Kenya continues to be severely undermined by a cycle of institutional failure and social prejudice. A critical systemic gap in the complicity of the police through harassment, arbitrary arrests, and abusive investigative tactics, which effectively weaponizes colonial-era penal laws to settle fundamental constitutional human rights and other human rights defenders. So even the analysis of the judicial decisions proves that the legal framework to protect LGBTQ rights already exists within the progressive mandate of the 2010 Constitution. The perpetuation of abuses is thus not a failure of law, but a profound failure of political will and institutional enforcement. And this culture of impunity within the police and justice sectors creates a hostile environment where victims cannot report abuse, and those who advocate on their behalf face immediate reprisal. This is a direct assault to the Constitution that guarantees dignity and freedom and has a very elaborate Bill of Rights. So there is a call of action and the deliberation. The time is for actionable implementation of the law, and we issue a call on all duty bearers. So for the police and justice sector, there is the need to immediately implement the mandatory SOGI training to all officials. There is need to establish a dedicated reporting mechanism for cases of violation and abuse against the LGBTQ plus community, and also to ensure that IPOA, IAU, the ODPP, KNHCR have the resources and political independence to enforce a zero tolerance policy against discriminatory police misconduct. For human rights organizations and lawyers, they need to intensify strategic litigation to cement jurisprudence and compel registration for all LGBTQ organizations, though this is already happening, and therefore strengthening the civil society infrastructure. Then for government and civil society, we need to have a collaborative and sustained cultural sensitive public education campaigns and integrate human rights values into civic education to dismantle this prejudice that fuels violence right at grassroots levels. And until the state prioritizes the safety and dignity of all its citizens, including the LGBTQ community, the foundational promise of the Kenyan Constitution remains unfulfilled. And therefore, the clarion call is for all of us to go through the report, look at the recommendations for each and every sector so that we can be able to move forward and ensure that we make steps, and these steps are non-negotiable towards achieving a truly inclusive and just society. And so with that, I think I'll end it there and open it up for any reactions or questions that anyone may have. Thank you for your attention.
Thank you, Aroka, for that comprehensive take through the findings. There's a question in the Q&A, and in case you have any questions, you can also drop them at the chat or utilize the Q&A. I've also shared the report with you on the chat in case you need to interact with it further. The question is, in the United States of America, which is noted as a different nation-state context to Kenya and vice versa, there's pushback by a number of human rights defenders there in terms of transgender persons being segregated from the human population in hospitals, for example, based on their said identity. Kindly share more about that gender facilities and court decision and how such a decision could be seen as segregating. This is from Portia C. Allen, a volunteer and senior advocacy coordinator.
You want me to take that one first?
Yes, kindly.
Okay, I understand. I understand. At times, you realize that some recommendations at times may come as a two-edged sword. They may actually be able to enhance human rights protection, and at the same time, it may lead to alienation as it is. So I think it's something that needs to be looked at critically, because if you go back to the Deprivation Against Liberty Persons Act, which the court used to request that we need to have units that look at the third gender, those who, the transgender persons and all that. And I think it's something that can be balanced in that the individual can be given that opportunity to be able to state where it is that they're comfortable, and then they are placed in those particular units as it is. But then, as we have put in our recommendations, all these recommendations, even the one for having the transgender cells, all of them are interrelated. We need to have already an environment that is embracing, and we do not have all these violations. So that's why we realize that there needs to have a lot of community education and sensitization, so that people already realize that by a person being transgender, it poses no risk to anyone. It should not be an avenue for one to be discriminated. In fact, they need to view those separate holding units as something that will be able, it should not be looked at, or rather, it should not be used as a possible avenue for targeting individuals, because I think that is where the question is coming up. So, for instance, if you're in a police station and you have a cell for men, women, children, and another one for transgender, already you have already flagged yourself out as a transgender, and you may have yourself standing out like a sore thumb for physical violation, sexual violation, the discrimination, and all that. So, as I've said, even as this is being implemented, we need to look at all those other aspects, including the community education and sensitization, working with the police officers, so as to ensure that this again is not used as an avenue. So it needs to be a collective effort that looks at all those different aspects. But if looked at on its own as a standalone recommendation, it may not, but it has the potential of also leading to further violations because of that singling out. I don't know if I've responded to you comprehensively.
Thank you for that, Aroka. Portia, if you have any follow-up question, you can also still follow up on the chat and the Q&A. And the Q&A and the chat is open for everyone in case you have questions. We'll also have a session thereafter that will get to ask the questions and have a plenary. For now, I wish to welcome my colleague Nelima to take on the next session. As we continue further to explore what are the findings and what is the lived realities of us as queer persons in Kenya when interacting with law enforcement. Nelima, over to you.
Thank you, Melody, and thank you, our able advocate Aroka, for that detailed presentation that is really, really insightful in terms of legal matters, in terms of lived reality vis-a-vis our legal context when it comes to human rights protection. Just to add a little bit about the question that was asked, I acknowledge that the court directed actually the government to establish a third facility or a third section for the community, and it was very clear. I know we are entering into a panel discussion, and the next panelist or next speaker, who is an advocate also, will touch on this matter, whereby they'll be looking at identities vis-a-vis our constitution. And I understand the directive was meant to reduce harm and ensure safety for the community, and not as a segregation as it may look, as our advocate also Aroka had earlier on responded to. Now, so thank you so much for that session. I know most of us are having questions or maybe just digesting the conversations through the findings. But because of time, I'd like us to take us through the second session, which is a panel discussion. And as my colleague introduced me, I'm Nelima Esther, working with and for Initiative for Equality and Non Discrimination as the program officer collective action. And I'll take you through this second session. So with me, I have our first speaker, who is Kelly Kigera. Kelly is a Kenyan community organizer and a program officer at ISHTA, and also a human rights advocate dedicated to advancing health access and community empowerment for marginalized and vulnerable population. So Kigera has extensive experience in grassroots mobilization, program coordination, and community-led intervention, and has worked closely with organizations and networks focusing on HIV prevention, mental health protection, and social justice in Kenya. Kelly works centers on creating safe and inclusive space for queer communities and continues to advocate for inclusive systems, equitable healthcare access, and safe environment where all individuals can live with dignity and freedom. So let us all invite Kelly. Welcome, Kelly. Okay.
Thank you, Nerima.
Okay. So our next panelist is our advocate, Okwara Masafu, who is also a Kenyan-based queer feminist and an advocate of the High Court here in Kenya, and legal expert specializing in SOGI, SCS, and the law. Their human rights defense and legal work focuses on the intersections of law, dignity, and resistance, and the human rights protection of lesbian, gay, bisexual, transgender, intersex, and queer Kenyans, as well as refugees and asylum seekers. Masafi is an inaugural global fellow at Harvard University Carr Center of Human Rights, where her research documents the development of queer jurisprudence in East Africa. So currently, she is the senior program officer at the National Gay Lesbian Human Rights Commission, where she coordinates the National Public Legal Aid Service Center, which specializes in providing high quality pro bono legal services to all LGBTIQ plus individuals within the country's jurisdiction. Masafu work has been recognized through the Legal Champion Award from the Cosmopolitan Affirming Community and Innovative Lawyers Award for Redress. So help me to welcome Masafu. Karibu sana Masafu. You can just unmute to say hi. Okay, thank you. There you are. So karibuni sana. I know the report actually it's very heavy, but this time we want to test on how between the report from the findings that we have and with the lived realities within our Kenyan context. So we'll take you through this session, and we'll be sharing different questions for our panelists to share their experience based on their field that, as I have introduced, they're well equipped in. So my first question will go to Kelly. I know, Kelly, you work in the grassroots. And please, if you may allow me to describe everyday challenges that LGBT persons face when interacting with law enforcers. So at the police station, I know you have had interactions too when you're responding to human rights violations, or maybe reported you have communities who have accessed police station when access services. So what are these challenges that you think communities have experienced?
Thank you so much, Nerima. An amazing report that INEND has collectively put together that is really defining on what is happening on grassroots as well. and what is actually happening within the communities we serve, and how that report reflects to each and every challenge the community goes through when trying to report a case, when they are arrested, when they are physically abused or illegally arrested. So technically, when communities report on the grassroots, so there are usually different ways of how communities report on the grassroots. There is an individual part of how communities report in the grassroots, and there is the paralegal way of how communities report in the grassroots. And there is also the advocate way of reporting cases in the grassroots. And there is also the police interventions on reporting of cases in the grassroots. So when you look at these issues, they come to social justice in a different angle, whereby majority of the communities do not understand the criminal procedures of a police station. Like, for instance, they don't know how to report an OB that you're supposed to also get a charge sheet in case a perpetrator has been arrested. Like, they do not understand the criminal procedures. And this becomes a challenge because they think when they report to a police station, that is enough, and you're given an OB, that's enough. But they do not know that there is always someone who is attached to that case that they're supposed to follow up with in regards to investigations, ensuring that the perpetrators are arrested. So there are different three ways of how communities meet challenges across the communities, right? And the first suspect is a fear of police. Like, queer people are afraid of police. The worst thing you can do is take a queer person to a police station. And that's why you find when our communities are blackmailed, they tend to pay the policemen in a police station so that the case can end. Be it they don't know that the Constitution actually protects them with the right of privacy. And blackmailers are the ones who are supposed to be arrested. So there's always the fear of not reporting cases, and the fear of police, and the not understanding the criminal procedures within a police station. So there is that inducted fear that the police try to betray. And to be honest with you, based on the experience I have, the police also do not understand the Constitution as much as they say. And that's why when you move to a police station with an advocate or a paralegal who really understands the procedures, the police tend to tone it down because now someone else understands the criminal procedures of a police station and what is expected in a police station, right? The other challenges is the fear of not knowing that most police stations nowadays, knowing the place to report, have a gender desk. Some of the most police stations have a gender desk, and communities do not know where the gender desks are located. They also don't know that there is a criminal rooms where they're supposed to go to when their case has already had an OB. They do not understand also the ranking of the officers within a police station. You know, the ranking of police officers matters within a police station. You know who is a sergeant, you know who is a corporal, you know who is a senior sergeant, you know who is a chief investigating officer, you know who is the DCI. Like, you don't know about IPOA, how you can report to IPOA. So there is so much that the community is not aware of the criminal. As much as we have a really, really progressive constitution, communities still fail to understand the criminal procedures or understand the roles and responsibility of each officer within a police station, so that they are able to report cases really well. So for me, the challenges I see is communities fearing to report cases, community being afraid of reporting cases, and community having the fear that being gay is illegal, so that they cannot seek justice, and community not trusting the justice processes. So those are the challenges I usually see on the ground, and corruption. And corruption. So there is so much into praise, and when you introduce corruption, police will always say, the LGBTIQ plus community have a lot of money, we should extort from them, and we're going to ask for more than 10,000 from them, or more than 5, or more than 50,000. So those are the issues that I see in everyday, and that's why you find most cases don't move ahead in the criminal procedures. They just end up being solved in a police station where this case would have created jurisprudence of communities actually reporting and ensuring that, we have a process of evidence to claim that we are being consistently violated by certain branches of government. Over to you, Nelo.
Wow, thank you. Thank you, Kelly, for that. And actually, what has stood out is that there is fear, which you have alluded that it is really contributed a lot because of lack of either awareness of and not understanding the criminal procedures within the country. As much as I know there's a lot of sensitization that has been done within our communities, still there's a lot still needs to be done. And I think the gap also is within the institute itself. And when you mention about the gender desk allocation, I was like, sometimes you walk into a police station and you're like, where's the gender desk? You expect to find maybe one person seated in an office, and then you find like there are 2 people, 3 people sharing the same office, which really doesn't speak to the name of what it should represent. And it's so unfortunate, maybe to you, Masafu, now that we have understood what happens, why communities are not reporting, why the challenges that they experience when reporting when reporting. Maybe you tell us to, given our constitution, I know it protects our identity, and this is a question that also has been asked earlier on and shared and responded to partly. And I think maybe you have more insight on it. How does the Kenyan Constitution protect identities, and why identity itself is not criminalized under the law?
Thank you so much, Nelima, for that. Hi, colleagues. Good afternoon, good morning, and happy almost Pride. Allow me to actually pick up where my very good colleague Kelly left from, so that we can work together as I demonstrate the answer to the question that has just been asked. How comes we have a very robust constitution, but kwa ground vitu ni different kabisa? So number one is, all of us, even just as a Kenyan, before you are a queer Kenyan, before you're intersex Kenyan, before you're transgender Kenyan, when you walk into a police station, there's this inherent fear you just get, or when you see a police officer, there's this fear you get. And I want us to think back about think back to our, early education, both in primary and high school. It may not be the situation for the current Gen Alphas, but back in our days, sisi kama wakongwe, when you'd see a prefect, you'd get a lot of fear. And it's the same fear that we still get when you see police officers. And when we critically look at this from a legal bird's eye view, is that this fear is engineered, that it's systemically engineered. And one of the things that this report captures with such precision is the divorce between what the constitutional promise, what the constitution promises to us as LGBTQ plus citizenry in this country, na kwa grounds, there's a very big contradiction. So ultimately, what we are trying to draw attention here is there's a very huge contradiction. And this stems back to, and this fear, this systemic contradiction, this deliberate, calculated, engineered systemic contradiction and fear that we are witnessing is attributed to the colonial legislations that still exist in our legal textbooks. And those colonial legislations actually are a heartbeat or a central contributor to the legal system that we have at the moment, that we still feel the effects of colonial legislation that is over 93 years in our everyday lives as LGBTQ plus Kenyans. So yes, this contradiction, just to summarily describe what our current legal framework, and especially to LGBTQ plus persons, is that on one hand, we have a constitutional promise And then on the other hand, the lived realities, there's a very huge contradiction. And one of the beauties of this report is that it captures that contradiction with such precision that the Constitution has promised us one thing. And then when it's time for these constitutional liberties to actually be implemented and for these promises to be, to be extended and to be fulfilled, then that is where the government draws a line. There is this particular animation, I think it was done by Human Dignity Trust, where they put a picture of the Kenyan Constitution, the very liberal Kenyan Constitution that has been celebrated by many as one of the most liberal pieces of legislation, not just on the African continent, but on the globe. And there's this picture that says, when it comes to homosexuality, shred that document. And it's a very apt demonstration of the contradiction that our Constitution currently is. And number two, just to answer that, we also have to be conscious and aware that these systems are not just a coincidence, that they were engineered that we continue to live in fear. That, and just like I've said, the ways that we continue to feel the effects of the colonial legacies in our everyday lives, even today as we, even today as we, even though we have done a lot of work to agitate, and I mean agitate for constitutional liberties, we still feel discrimination. And as I finalize on this question, I'll finalize with just a very brief story. When the National Gay and Lesbian Human Rights Commission was walking the journey of finding justice for our sibling Edwin Chiloba, I remember very, very vividly, every time we would go to the DCI headquarters in Thika to follow up on the investigations, it was such a shocker that the DCI had actually done their job. And it was very difficult to believe that they had actually done the investigations and they had documented the investigations and they had taken witness testimonies and they had documented, they had put together an investigation brief. It was a shocker even for us as, legal practitioners, and especially queer legal practitioners, because there's this absolutely lack of trust in our law enforcement. Ultimately, what it comes down to, even though there's this contradiction exists, is that strategic litigation cases, as we've been taken through by our senior Aroka, these cases have actively demonstrated identity and constitutional protections. And one of the most beautiful things that have come out of our courtrooms is the demonstration that, for us queer Kenyans, we do not need, courts have actively told anti-LGBTQ plus aggressors that we don't need social approval to access our constitutional liberties. And our constitutional liberties cannot be limited based on the social approval of the majority. So the courts have been very clear in saying that our identity as LGBTQ plus citizens in this country is not a crime. And the courts have interpreted what exactly it means when our constitution says all Kenyans. It also includes LGBTQ plus Kenyans. Back to you, Nelima.
Thank you, Masafu, for that. And I really like this because when you look at what the courts are doing, they're really doing remarkable work. And when it comes to the directives that the courts really give, it really leaves a lot to be desired. And I was out here actually thinking that, starting with Baby A case, where the court gave directives also in terms of access to service for intersex persons to be as the third gender in the country, you still struggle when accessing services, let it be health, let it be in prison, like still we are struggling with the same things that the courts have really given good ruling on, and actually still is touching on us. And given the case, the Eldoret case that was shared during the findings, and also you shared about it, that there are other even directives that were given, but still, I don't know, is it struggling with resources? I don't know if you can respond briefly on that before we go to the next question.
Part of, and I started by moving us towards us looking at the consciousness that we need to have even when we're interacting with the laws that criminalize our lives. The way the system is structured, or rather the way that these colonial legacies were structured. And I want us to think of when you're cooking pilau, you already have an idea of how you want your pilau to come out. So that will give you a direction of what ingredients to put in. And the ingredients that the colonial violators were putting together was creating a system whereby 93 years later, that we as LGBTQ plus persons continue to live in fear. So these criminalization systems have continuously been engineered and architectured to sustain fear, vulnerability, and discrimination. And a very good demonstration was the example that my amazing colleague Kelly gave. Queer people, transgender Kenyans, intersex Kenyans, we are scared as shit when we go to the police stations. So back to the question is, part of this system is that even when it comes to implementing some of the court orders, when the court has said, listen, the government, dear government, constitutional liberties should not be anchored on social approval. You're supposed to follow the law. When you lift up the constitution to take an oath to uphold the mandate of your office, you're supposed to uphold the constitution as it is. So when you find that the same institutions actively failing to implement what the courts have said, it's also part of the system that instead of directly implementing, then frustrating the process. So when the court says, for example, in the Rafiki case, you're supposed to do A, B, C, and D, but you find that the very constitutional mandated state agency actively decides to frustrate LGBTQ plus Kenyans trying to access constitutional liberties that are constitutionally promised to us. So ultimately, to answer your question, Nelima, and for us to think as food for thought, is that the system is engineered in a manner that our access to constitutional liberties is continuously frustrated, and that the ways that we live in fear continue to, that our life, the way we live, the fear that we feel is sustained through these systems. So even when we see constitutionally mandated state agencies actively refuse to implement court orders, it's all part of a system that is meant to continuously subjugate queer, trans, and intersex Kenyans. But that's not to say that we sit down and take it. It means that, and one of the things that the report has beautifully documented is resilience. All through from page 11, page 11 of the report, which talks about SC's case. All of these constitutional challenges are actually a way that we resist this system that has been created for us to continuously live in fear. Back to you, Nelima.
Wow, thank you. Thank you, Masafu. Before you take a breath, just on the same, you have shared these remarkable successes in terms of the landmark rulings that we have had. I know sometime back, was it in 2019? Not 2019, around sometime back, 2015 there, on the case of first annual examination, you mentioned the case for 2019, that is the SC. And then we had the freedom of association, the case with the organization. That these are remarkable cases, and now we are having so many cases that we're really celebrating today. But now, looking at these cases, how can we advance the legal accountability for our communities?
How do we advance legal accountability? And especially in a system that is architectured to never make that possible, is to continue with the resistance that the report documents, strategic litigation. And it's not just a matter of going to court, it's about a matter of going to court and actually doing movement lawyering, strategic litigation that is anchored to intimately respond to the justice and legal needs of LGBTIQ plus Kenyans. That even when we are packaging these cases to go to court, we're not just going to litigate in court for the sake of litigating in court. That our ultimate goal is to shift this system, that this 93-year-old system that was, the infrastructure of this 93-year-old system that was meant for us to never have our voices. So number one is to continuously put up the resistance that we have collectively done. Massive acknowledgement to LGBTQ plus seniors, stood at the edge of possibility and showed us what is actually possible. So ultimately to continuously continue in strategic litigation while acknowledging that strategic litigation is not enough. Because yes, we've gone to court. Yes, we've gotten accountability, but is that enough? Also, just realizing that parallel to strategic litigation is the need to continue doing the work that we're all doing, non-shift work, those who are doing podcasts, those who are doing non-shift, dismantling the system through art, those who are dismantling the system, just our existence, having your own profile, those who are living out and proud, for those of us are refusing to be arrested, and for all of the work that we continue to do, that this, for us to bring this shift form of criminalization and overhauling this entire system, is to continuously put in the non-shift work that all of us are doing, from grassroots all the way to corporate places, all the way to donor spaces, all the way to those even colonial spaces, in courtrooms. So it's to continue living the lives that, while isolation recognizing and institutionalizing our work to actively go towards resistance work, and as well also queer joy. This system was not structured the ideation that will queer joy. It was structured to oppress queer people, to suppress the voices of transgender Kenyans, to never make the realities of persons come to life. So resistance and overhauling this brought this those certificates as the report documents. And finally, to just continue with and a lot of flowers for everyday community violence respond to these cases. Make sure that there's a police report, that when a police fails to do their job, that there's an IPOA report, that there is a peace reform, that there is there's a trace. So this documentation that continue to is not just a matter of work that we have made, but it's also resistance to the system that is meant to oppress us and silence our voices.
Wow. Thank you, Masafu. I can see many questions and comments are coming in. Before I get on to that, Kelly, I hope you're still on the call. So, with your experience in response, maybe can you give us a few, take 3 minutes to take us through the practical steps that our communities can navigate while accessing justice?
So, with the key respect, when you're responding to violence, you have to ensure that safety comes first. So where you are, we usually look at safety first. For e.g., for example, I am responding to a case at Bambuli, at Kwapastalai. and there is a mob justice that is happening near pasteurize place that they are assaulting maybe a gay man or a transgender person in that location. So the first step is trying to analyze how secure that place is and activate either a paralegal to be on the spot or someone who is nearby to activate to be on the spot. Secondly, there is usually like we work with, yes, at times we do look at police as the worst people, but at times there are police officers who might be very allies to us that are able to respond quickly. Once we respond, so there's steps we take, either medical, if it's injuries, medical, we ensure the first thing the client has is medical support as well. So they're able to recover within the space as well. So if they don't need medical, we try and look at also the perpetrators who are involved as well to try and see the root causes of the violence. So for instance, in major cases, we find that we as queer people, we are provoked, we get provoked verbally so much to the extent we start abusing the perpetrators. And that's what maybe times physical assault tends to happen, which is not justifiable as well. But in that nutshell, no one has the right to physically abuse you. So the way the paralegal do is you mark who was there as well. If there is a video or evidence-based, the paralegal or the person responding will have to look for all those evidences in terms to evaluate a case. From there is a reporting process. So the paralegal and you or the perpetrator will ensure, or not the perpetrator, the victim, I don't want to use the name victim, I want to use the name survivor, will necessarily work together with the paralegal to ensure that they have reported the case through the procedures of within a police station. So the reason why at times we tend to involve the paralegal or the advocate or a safety and security person is because they will guide you in the processes of reporting. And that's why they are very important, because the reason why they are there is because at times we fear a lot to report, as Masafu said. So within that process, once we report and document and ensure that they're evidence-based, the paralegal comes back and does more investigations towards finding the perpetrators. For instance, if it's a blackmail, where was the location? Is it in the pasterized place at this house? Who are the blackmailers? It was 2, 2, 3, 4. Do you have the photos? Yes, they are this and this and this and this. What numbers were they using? This and this. Did they withdraw the money? Yes, this is the money they withdrew. Do you have a statement for the money? Yes, this is the statement. This is the number that was sent to the number, for example. So once they have that evidence, they have enough evidence to start looking for the perpetrators. So what also at times, if the police are not very supportive, there's something we call also citizen arrest. At times, on my end, we tend to also to do something we call citizen arrest, where we look at the perpetrators, we war them as well. So at times we also respond and say, I'm going back to that space as well. Let them hit on me, or let me go online because they're blackmailers. Try to woo me on the space as well. We do a citizen arrest as well. So there is usually conjoint efforts to try and put this perpetrator in base. For AG, last week we were responding to a case in a place called Feather, where 5 blackmailers were blackmailing a certain gay man. And we found that within the 5 blackmailers, they were also members of our own community. So you find also members of our own community tends to blackmail the members of the queer communities as well. So within the midst of all that time, we decided to investigate further. So we had planned, we had communities around the area who would identify if these perpetrators go back to the house, and we will go there and also update the police officers and go and arrest the perpetrators. So there is so much wins we have had of late, especially with Masafu and Ligora, who have actually supported the act of ensuring that blackmailers are put to justice and they are arrested. So each and every key community member is a key player to ensure that justice takes place. But the major challenge comes in when no one wants to go ahead. There is the withdrawal of cases at times. No, I'm tired. I don't want to be out. My parents will know I'm queer. You know that my family will out me. I'll be outed. My wife will know. My pastor will know. So there is usually that challenge. But within all that challenge, the case can be treated as private as it can be if the lawyer asks for the case to be treated private and not to be a public case, you know?
Okay. Yeah.
So that fear we have of not reporting is the one that creates so much injustice to continue. For instance, when the same perpetrators were blackmailers in Mombasa, they came to Nairobi, right? But
Mhm.
but they were still being looked for by police officers in Mombasa. But when they came to Nairobi, they found that we were also looking for them. So we found the cases that they had in Nairobi by blackmailing a white man and stealing from and killing a white man in Mombasa. I think it's Diani. And then they came back to Nairobi. You find the angle of them, and we arrested one recently, you know? So there is correlations of the same perpetrators if we do not report these cases. Same applies to rogue police officers. For instance, you find like in Thika, we had rogue police officers who used to blackmail queer people and arrest queer people and use young boys to woo queer people online on Facebook, especially when it comes to Thika police station. So you find that if we had people reporting these police officers, they will stop doing whatever they're doing amongst the community. But they were fear of reporting a police officers. You can report a police officer to a different police station. People do not understand that. It's not a must you report them to the same police station. Plus, you can use
Mhm.
the IPOA means of reporting a police officer. So the challenge you usually have when we come to police officers who are rogue and they are working with blackmailers as well is that
Mhm.
they think that we are not, they think that being gay is so illegal that we cannot, that these cases cannot be reported or they cannot seek justice. That's where we go wrong as communities. We can win
Yeah.
these cases, and the cases have been won before. So in the minutes of responding, the challenges we get even demotivates the people who even responding, right? So you
Yeah.
find you get too tired, staying in a police station the whole day. The challenges at times you can stay in a police station the whole day, waiting for an OCS, waiting to get that OB, waiting to get that charge sheet, waiting for the criminal investigating officer, waiting for either the DCI inspector who is attached to that case. People do not understand that this takes a lot of resources for one person to wait for an entire day to try and seek justice. Again, the following day, maybe the OCS did not come. You have to wait for an OCS to come the following day. So the process
Mhm.
seeks to go
Yes.
step by step, but you find that our own community tends to give up on the way of seeking this justice, right? The other
Yeah.
thing we found that when we are responding, also as communities, at times we are fearing arrested. For example, I remember a case of a trans woman who um, was told that they had stolen money and a phone from a crab, which was not true, just because of their identity. So they were profiled. So there is that part of profiling, and this trans woman was raided to a cell and was put in a remand prison in Nairobi prison, where they were put in remand for almost 6 months, and they were still receiving violations when they were in prison, right? So we have to also intervene and ensure this trans woman is also put in a safety in a safe space in prison, because we had a case that she has been proceeded at or with theft, but the perpetrators who were saying that she stole did not have evidence of what they were claiming they stole. But when you look at
Yeah.
the CCTV, you find she's not the one who took. So that was a case of profiling, just because they did not
Yeah.
want that testimony, that crap. So you find that
Sad.
different. We end up winning the case and winning the case because there was no evidence to claim that this trans woman stole the phone, but this was a case of stigma and discrimination and profiling. You get the angle of just
Wow.
at times we go through a lot of challenges, and also signing for a surety for our community, and then our community is not coming to court. You've been, for example, you sign a surety, maybe you're being arrested, and maybe someone said you've been put on a case, or maybe a sexual case, and we know this is not true. People are just trying to steal from you, or people are just, there's ragos around maybe rand. for example, in your home, because you're gay, they say you raped a child, or sorry, you raped a child, which is not true, or you stole something from the neighbors just to ensure they inherit your land, right? But when we go investigations, do further as paralegals, and we find this is not actually a case. This is a sign of stigma and discrimination to disinherit you, right? But then when we sign for you that's an example, an assurity that you will appear in court with the several days that we are going to support. Maybe there's a pro bono lawyer, maybe it's Masafu is there. And me as Kelly, I've signed for you an assurity. Assurity is a procedure where you sign for behalf of to release a client to ensure that they appear in court every day and to follow up on a client. So you sign for them, and then after you sign for them and they are released from prison by paying either bail, they are going to appear in court consistently, right? And then they fail to appear. So you're the one who's going to be
Wow.
So basically, challenges we can go through when you're trying to support the community. So there comes to a lot of response mechanisms that are laid on this, but you find that it all goes to the community members who want to seek justice. The other thing is something we call alternative justice resolution or mediation. At times within communities, maybe you are dealing with IPV, that is intimate partner violence, and decide you're going to have, for example, alternative justice resolution. You have a colonial-era and the police is there in the police station. These two had ragos, a boyfriend and a boyfriend, or a girlfriend and a girlfriend, and they ended up breaking things, and then we decide you're going to pay this, and this one is going to pay this. And then again, you're back together. And then you find yourself in the same police station again. And then you fight again, and then again in the same police station. And we find that to be very, at times it gets, yes, it gets tired because IPV, yes, it's amongst our own community, but at times it gets tired when you're responding to one person. After every 2 months, you're in the police station because of the same person, right? After every 3 months, you find yourself in the same person, and they're two, and they're fighting. The other thing is more of neglect. So you find there's also something we call neglect. Neglect is part of violence, where you find partners that are neglecting their own partners in the house. You're staying with someone, they're not eating, they don't have a job. So there is that abuse of neglect. They don't have financial support. So you find that when you're responding to such cases as well, you find that the person is maronished and they're only being used by another partner. But when you tend to report that case to the police station, you can't actually report it well because you find these are two people who are cohabitating together, right? So it leads to such challenges. And also the other thing we find with queer people, financial violences that I've also seen. So financial violence is people taking money from their fellow queer people, and then you tell them they're taken to police station, and then they're arguing that I gave this one 20,000 shillings, they did not pay me, and that's why I'm going to out him to his family. So there is that leeway of communities themselves fear themselves within the communities violating themselves in the space as well, and also communities themselves not trying to abide by the book of the law because no one is above the law. So we really need to look at also how ourselves, even if police at times they might be stepping on the way, we also need to look inwards ourselves at times, right? And understand that we are also not above the law because we are also queer and not privileged. As we are not as privileged because we are queer as well, So that's the way the experience I have seen within the community. If I miss something, I'll come through.
Okay. Wow. Thank you. Thank you for that lived reality. I know it's not easy being a respondent, the back and forth, sometimes limited resources, being in this world where donor funding is shrinking, and even money is just to support the response, and just access to justice is just something else. And there's a point where you mention when you are giving the steps about collective response, and I think it's very strong in terms of human rights violations can never be redressed by an individual or just one organization. You need support from from partners, from allies, to ensure these are a success. Maybe if we were to give the opportunity to Masafu or even Aroka just to share, because I know the cases that they have not handled as individuals or as an institute alone. You have gotten to collaborate with other institutions or other civil society to ensure this is a success. And if we continue holding our hands, I know that way, eventually we'll achieve it. Maybe time is really not on our side, but either Masafu or Aroka can take this. I know we have talked of the victories, and we have talked of some of the strategies that we can complement community efforts. Maybe just to put it now in context in terms of efforts that we can hold our duty bearers accountable. How can we hold our duty bearers accountable given the victories and the strategies that we have in litigation? So whoever is ready can. Masafi, you can proceed. I can see you're smiling at me. Yeah.
In the legal profession, let your senior go first. So, and if I may respond to this. So we are starting from a point where we're actually Marshall. Are these constitutional promises, will they actually translate to be? I hope I'm audible.
Yes, now you are. I thought that might have an issue there, but you are now.
So we are starting from, in responding to that question, on how do we, so we've gone to courts, and the courts have then interpreted what is already clear in our legislation that all persons, but state agencies continue and consistently fail to implement what the court has ordered. So how do we hold our duty bearers accountable? And our starting point is asking ourselves this question: are our constitutional promises just theoretical promises, or are they constitutional practices that whose impact we must feel in our everyday lives? And from that starting point alone is to ensure that we are agitating for, number one, things like mandatory human rights training. And I'll give an example of what the Kenya Human Rights Commission, the Kenya National Commission on Human Rights is doing. That it's mandatory for all staff to be intimately aware with human rights. And when we're talking about human rights that is not segregating of human rights based on sexual orientation, gender identity, and expression. I'll give maybe just a practical illustration of how we continuously hold duty bearers accountable. And I will depart from this point where I'm saying every time a state officer takes oath of office, they lift up the Constitution, not the Bible, not the anything, the Constitution. So that therefore means that they are mandated to uphold that Constitution. So that therefore also means that even with this, we've gone to court and the courts have said we don't need social approval for us to access our constitutional liberties. So where does that leave us then? It means that we also cannot sit back and wait for our constitutional liberties to be handed to us on a silver platter. And as the amazing Winnie Mandela said, human rights are not things that you go with politeness. It's as if you're going to a picnic to collect. Human rights are things that you have to agitate for, as we have continued doing. And is to ensure that, for instance, if a police has entrapped an LGBTQ, say a gay man on Grindr, the thing is to document, file the case at IPOA, let the record always reflect that this particular police officer violated their constitutional oath by, doing A, B, C, and D. And then these records, these are not just records, they are essentially, they essentially become there's a record of injustice, that it's not just an abstract idea that, queer people go through violence, that we actually have documentation of that injustice. And one of the things that I've come to love is what is coming out of our constitutional courts is that the courts are actively saying, this is not an identity issue, this is a rule of law issue. So ultimately, even when we are strategically litigating, one of the things that we are saying is that we don't want to hear about the Bible. We do not want, like we're telling judicial officers, don't quote for us, don't quote for us religious texts. This is a rule of law issue. This is a fundamental human rights issue. And we are continuing to hold to account, for example, what our very good siblings and colleagues have done in Mombasa, that Mohammed Ali, a public officer, entrusted with the Kenyan vote to protect and uphold that constitution, is actually using their state power to legitimize abuse against LGBTQ plus persons, but he's been taken to court individually as Mohammed Ali, not as, so and so. So those are the ways that we have continued to uphold, to ensure that there is accountability, that it's no longer just, I can go out and say whatever I need to say and I'll be protected by the institution that I represent. Accountability has now moved to individual accountability. And the everyday practices that we continue to see, that we are seeing blackmailers are getting arrested, that if the state has fundamentally failed to uphold, for instance, Resolution 275 to protect LGBTQ plus Africans against violence, that we are reporting that the state has failed, and here is the evidence. So all of those documentation, as I finish, and all of that constitutional litigation that we are agitating for, they're not just a way to resist, but they're also constitutional memories that continue to show this is how this constitution has fundamentally failed LGBTQ plus citizenry in the country. Back to you, Melly.
Wow, thank you. I hope you've gotten something there to just see how we can leverage on in terms of our advocacy, especially around with officers. I can see Aroka is on. Aroka, you want to add something?
Yeah,
Our senior?
I think yes. Masafu has pointed it out quite well, and I think, just as has been said, let us not get fatigued. Let's keep pushing and pushing and pushing. If a court has given a decision and the decision is not being implemented, if you're not able to go to the hierarchies, go back to the same court, file for contempt. And this is something that is not unique only to our LGBTQ plus issues. I remember even like for the 2/3 gender rule, from 2017, we kept on going to court. I remember like Justice Mativo the first time even gave us like a time frame that a formula has to be made within, I think, 3 months or 6 months. 6 months happened, the government wasn't doing anything. And we kept on pushing it. In fact, I gave up. I don't even know where we are at right now, because different formulas and all that. So I'll just add emphasis. Let us emphasize on the formal way in terms of going back to court. Apart from that, let us also do the non-formal engagement, the institutional and policy engagement. Let us be at the forefront. I know we have a number of organizations doing a lot of good work at policy level and all that. Let us be the volunteers to government and say we're going to come in as a public-private partnership. I know there's this decision that has come from Court XYZ mandating you to come up with a policy on this. You're going to help you with this and all that. Having those informal discussions also really help a lot. And even just sensitizing, because I think when it comes to LGBTQ plus issues, not many people understand the issues around gender diversities and the human rights standards. Even just having that meeting, and it may be a roundtable meeting, and just tell them this decision, do you first understand what it entails and all that? I think that goes a long way. And I think one of the challenges that me and my team had is the lack of documentation on all these issues, because the other thing that can be done we can go back, maybe the different suit or to the same court and say, look, by failing to implement this clear court directive, this is the effect that is happening at community level. I know there are organizations doing beautiful work, but my feeling is that most of it ends at us reporting to the donor. Once we report to the donor, that's it. We are not using that information to translate into policy guidance and also to help us into all these strategies. Because when you have the evidence, it's very difficult for someone to ignore you. But other than that, and I think still related to that, the monitoring, evaluation, and learning. Let us monitor and evaluate each court decision. What is the impact? What are the gaps? And if there's anything new that comes up as an emerging issue, let us not tire. Let us go back to court. Let us be part of processes. I know most institutions, government institutions, talk about resource allocation. But for us as communities and human rights defenders and institutions, how many of us are strategically positioned during the budgeting process so as to ensure that we as organization S, we know there's this decision whereby each police station was to have maybe a cell for transgender persons. So do we even have those memorandum? We go and say, we have this decision, it needs to be implemented, it needs money. So we need it to be part of the country integrated development plan and all that. Being in there and having our voices heard, because I know most of them will tell you, hakuna pesa. But if you go even and look at the budgets, and I know now we are coming to the end of it, you realize the priorities for the country are totally upside down. So as Masafo has said, if you're not invited at the table, get a seat, get on it, and ensure that your voice is heard. Because again, when it's a responsibility, it is not something that is bargainable, because it goes back to what Masako had said about the colonial mentality, whereby we are made to feel that even these people that we put into government are doing things as a favor for us. So let us always just remember that they have a responsibility, and the guiding responsibility is in the Constitution. So anything that is anchored in the Constitution, anything that has been legally passed as a pronouncement or a law, they must adhere. And of course, also the human rights monitoring and shadow reporting. Let us be part of those processes. Let's go to New York and those countries and say, I'm coming to report as a Kenyan institution. This and this is not happening. Our country is lagging behind in point 1 to 3, despite the court making the pronunciations and all that. So I think all these are doable, and part of them are in the advocacy strategy, part of the report, and also the recommendations, some of the active action that we can take up at our all individual levels or institutions, just to ensure that we create a better environment for the beautiful work that all of us in here are doing. Thank you so much.
Wow. Thank you. Thank you so much, Aroka. Wow. Now, I know, as I mentioned, time is not on our side. There were just amazing strategies on what we need to do after this, and I love where this is going, because after the report, you are like, no, we need also to sit back and see, do we need a policy brief? Do we need to do a petition? And hold these people accountable in terms of the ruling or the guidelines or the directives that the court had given. So thank you so much, Aroka, and thank you so much, Opara, for sharing that. Closing remarks. Kelly, do you have anything to share before we call it a day? In terms of police officers, how can we build trust as communities with them and reduce even the stigma and the discrimination? I know there are officers who have joined the call, and I know they look forward to hearing.
What I would say is we are all humans first, and everything else comes later. First thing is we are all humans and we are all humane. Let's be open-minded when we are receiving cases, because you never know what someone is going through, and we are all connected in a way or another. like we are human beings, but I believe we are all connected in a way or another, because you never know where you need me next time, and I never know where I might need you next time. So at times we are all connected and we are all human beings. And if I was in the police space, I do understand the challenges they also go through, but it's at some point we need to help each other as communities at some point, right? And the greatest advantage of all humankind is reasoning, understanding, responding, and as well as being there when needed for our community members, because at times we have all challenges we go through here and there, but listening is very important at times than just concluding. And let's not judge by the way a person looks like. At times we tend to say, oh my God, I may paint nails. Can you may paint nails? Can you may wear earrings? That is not the case of why someone wants to report. Because I have been asked that several based on my experience. Why are you wearing earrings? Why do you have painted nails? Are we earrings kuja hapa? At times, which demotivates even someone from proceeding to report. And this happens to most of our community members from not reporting, right? So let's just be as humane as possible. Let's not judge. Hiyo tu. Na utaona cases zinaripotiwa mingi sana. That cases will come, anything that will come will be reported, and I'm sure justice will be because I've seen police officers who have done amazing work. Trust you me, I've seen that we have worked step by step by step. They even call, we have arrested this, come and sign your statement, this and this done. And it's documented, right? Even if at times people lack resources to respond, at times as communities we say we have resources to take hiyo mafuta tumshike, because hao ndio wanatusumbua. And you get, at times that can happen, and at times it's there, at times it's not there. But it's not like justifiable, it must be there always, But it's just seeking justice that we want to seek justice. Because tumesumburiwa sana, and at times tunaendanga mafichoni, tunatokelezea. Community has a season on its own as well. So yeah, that's that. That's my part in short. Let's just be here.
Okay, thank you. Thank you so much, Kelly. So before I hand it over to Masafu and Liz, so allow me to just go through the comments, some of the comments, because some might have been responded to, others might not have been responded to. So on our chat, so we have someone who has shared a publication of a paper that is related to what we are discussing, but rather more on culture and religious tolerance against LGBT persons in 5 African countries. Maybe you can copy it, every participant that is here, and just go through it and get to know what it is saying. There's somebody else who shared and said there are cases of discrimination that come up as security threats when crossing the ferry at Likoni, and security officers working with the police officers to harass both trans men and trans women into profiling search and harassment in body search, and they don't consent to the search. How can such cases be tackled so as to educate and ensure that stops? So I think this is a question on what happens to the ferry. So I don't know if either of you have ever walked through the security checks, especially when you're not driving through the ferry. There are always security people there who do body search. So somebody is asking for support here. Either Aroka or Masafu can give insights to the question.
Okay, so is this case of discrimination that come up as security? So these are situations whereby a person is singled out, and they undergo through a further thorough search or something. I believe that's what the question is. Actually, I usually have a problem even with SGR. Anytime I go with SGR and I'm told, wake a bag candle, and a woman has to put her hands between my breasts and it's usually very, very uncomfortable. So I can imagine if it's a situation whereby not everyone is going through, because SGR is basically almost everyone. So you're like, "Ah." But I can imagine why I'm not being singled out because of my perceived known or suspected gender orientation or gender identity. I think then I would totally feel out of it. So I think it's something that can be taken up. And for me, the first step is always to just mention your discontent. Say something about it. Talk about your discomfort. Of course, take into account the security issues around you and all that. I just tell the officer, look, why is it that I am being singled out as against everyone else? What is the problem? I can see there is a queue of other men or other women. What is it that exactly looking at with me that is not with anyone else? And as I think had been said by Kelly, also document. You can get the details of that officer. Just document and the time. So that this time I was crossing the ferry. I feel that I was singled out in a way that does, because I'm not a criminal, I'm not whatever. I don't know why. It is that out of like 1,000 people who are crossing the ferry, had to go through an extra search and all that. Because the law is very clear. Even if the searches and all that are to be done, there are certain standards to be done. And unless there's something you're suspecting me of, you need to let me know about it. And probably have further discussions and seek my further consent on how that should be done. So things that can be done, one, first voice it, let the officer know that you're dissatisfied, let someone else say it, because the other thing is that people take it normal because no one complains. That si kila mtu anapita na hakuna mtu amecomplain kwani wewe ni nini. So I think the more voices come out, they'll realize, wait, this is something that is not comfortable. Two, we can do those roundtable meetings you're talking about. As its organization, we can ask for a meeting with maybe the security company, or it's no longer KPA that is running the ferry. I don't know, whoever they are, and say, we want to have a meeting. There are certain concerns we've had with that certain members of the community are not happy about. And you realize that some of them maybe will get surprised that, oh, that's an issue, because as has been said, there's a lot of lack of information on that happening. And if everything fails, go to court, do a class action suit, and say, and of course, with all the documented information on this day, you have like 10 people who've documented in a span of 3 months. We've had, at this time, it was this person who was searching, because maybe we realize it's a specific person. Maybe it's not as embedded, but there's this officer when they are there, and all these searches are done. So let us just embrace all that. We can even bring it as a discrimination suit. So of course, we'll have to get the other sample to show that the others were treated not as fairly. But nowadays, there are sophisticated methods of picking out that information. But as we said earlier on, do not tire. Speak up. Though I realize it's always easier when someone speaks up for you. So let us also do a lot of community sensitization so that they can speak up and say, hey, mbona huyo mnamweka kando? Kwani what is wrong with the person? That way people are able to respond much better. And there's that saying that says, if you do not speak when it's me who's being violated, when it comes to your turn, no one will speak to you. So let us also do that community sensitization so that people can also understand that even if I am queer, I am gay, I am lesbian, or whatever name you want to give me, I am not different from you. There's nothing that puts me apart. We are all human. We are all entitled to be treated with dignity and respect. Thank you.
Thank you, Aroka. Thank you. So allow me not to read these others are just comments. Somebody gave an highlight of the colonial laws that are discriminatory, equating them to anti-queer laws. And then there was a comment around the system, how the system works. And then there's a question here about to share findings about lesbians who face arbitrary arrests and detention. I know you will find some of these findings or some of this data in the report. And if not, maybe you can reach out to us. We can share some of the materials that might be having these statistics. And then, yeah, somebody was just sharing an idea of what we can do, uploading what Advocate Aroka had shared about developing some policies, directives to hold the duty bearers accountable. So having something that can really push out for that. So other than that, going to QA, was there any question which was not responded to? So there was a question, if I'm not wrong. Melody, is there any that, so the rest were just, yeah. Somebody was asked a question about would be how successful has it been to engage IPOA on cases of police abuse against LGBT persons? Masafu or Aroka, anyone who has any information regarding this, if we have any cases, any successes or something that is in progress?
If I may take that, Nelima.
Okay.
So my experience of almost a decade engaging with cases of police abuse, particularly at IPOA, has been that IPOA has been averse to meaningful engagement with cases of police abuse. So what would happen would be that they would take significantly long time to actually address any case of police abuse against, particularly against LGBTQ plus persons. And then it's even more difficult because part of IPOA is made up of actually police officers. So police officers prosecuting fellow police officers. So very few of these cases would actually successfully come out of the IPOA system. So either you'd find avoidance or the abuse that occurred on account of discrimination or on account of homophobia, transphobia, is actually, it's covered. So it comes out of something else. So you find that issue, you know, the way we say the issue is violence. So the issue here being discrimination based on sexual orientation and gender identity is not addressed. So you'd find that there is a lukewarm address to what the issue actually is. So you find half of the time these files go through the system as something else and not the discrimination that it is. That, however, does not stop us, like my senior Roka has said, is that we continue to file these cases and we continue to name those violations publicly. We continue to have the records of IPOA show that police number A, B, C, and D entrapped a gay Kenyan on Grindr. Police number A, B, C, and D refused to give services to, refused to investigate a case of murder. Police number this, and that refused to do that. But also looking at a more an adversarial way is there's an opportunity to engage IPOA, Kenyans at IPOA, and I say Kenyans for power purposes, that Kenyans who have been given the mandate to run the institution that is IPOA, there's an opportunity for meaningful engagement for officers at IPOA to actually understand what it means when we say this is the justice and legal needs of LGBTQ plus person. This is what abuse looks like. And ultimately also reminding us that IPOA has a constitutional responsibility to serve the needs of all Kenyans. And when we say utumishi kwa wote, it's supposed to actually be utumishi kwa wote. I think I'll stop there. Hopefully I've answered. Ultimately, to give figures, I would say only 2% out of 100% of cases have actually been successfully handled at IPOA. And I'm talking about cases that have actually acknowledged police abuse based on stigma and discrimination.
Wow, thank you. Thank you. Now, wrapping it up, our senior advocate, Aroka, 30 seconds. Tupatie your final remarks.
Is it the parting shot?
The parting shot.
Yes. Oh, so thank you. So, as someone who has been in the human rights space for the LGBTQ plus community for over 25 plus years, and looking back, I think we have made significant progress. We have made a lot of progress. I started this out right after uni, and whoa, that point, I remember even just having such conversations was difficult. In fact, even sending out an invite, you had to mask it as we are going to have a human rights training. Then when participants get in, that's when you share the agenda and all that. So I'm happy. I'm happy at the strides that we've made as a country. And I know the Constitution has actually helped us much more in terms of where we are. And I want to acknowledge all the different organizations, the good work that is being done. I spoke to a number when we were trying to get the data. So let us keep pushing, let us keep pushing. This is not a favor we are being done for, it is a right, and we must actualize. Let us not continue being the state whereby everything is on paper. Best constitution, best policies, where other countries just, best programs. Other countries just come and copy and paste, but let us actualize by doing what we can to ensure that the practice on the ground actually mirrors what is going on in terms of policy level, law, legislative level, and also institutional level. So let's go keep pushing. Let us strengthen our referral pathways. As had been said by Kelly, many people do not even understand where to start from when they have a violation. Let us know each other. We are all fighting for the same, working for the same work. So there's no fighting to feel like they are eating my cake. Let us just try to collaborate and work together because we are working together for one particular community. But as it is, let us keep pushing. And I'm here to help you push much further if need be. Thank you.
Wow, thank you. Thank you, Aroka. Over to you, Masafu. Your parting shot?
I think my parting shot has been, we've done the work, we have learned from the work that we have done, we continue to build. I'm not here to advise us, I'm just here to say we are Kenyans, we are tax-paying Kenyans. We will continue to agitate for our rights, our constitutional liberties to exist in this country and harness all of the constitutional protections that are guaranteed to us. And just to emphasize what my other colleagues have already said, that our existence is not anchored on the social approval of the public, that Kenya is not ready and Africa is not ready. All of that is just rumors by I don't want to mention his name, but rumors by anti-LGBTQ plus aggressors. Ultimately, is that we affirm that in our spaces there are anti-rights actors, and in their spaces we are also there. So we continue to fight the fight. When we get tired, we hand over the baton to those who come after us. Ultimately, by hook or crook, we will live our lives with dignity, and our constitutional guarantees will be accorded to us. So we'll continue to show up by doing community legal literacy forums. We'll continue to do what needs to be done to make sure that we continue to live in our countries, because we do not want to leave our countries to go to other countries. But before I digress, is just to say that, ultimately, a luta continua, no matter what.
Thank you. Indeed, a luta continua. We continue to fight on. So I'd like to say thank you so much to our able panelists and also for our consultant, Advocate Aroka, for this amazing work you've done. Sina mengine ya kusema, bali ni to take the ball ama the mic back to our moderator, Melody, to close up the session. Thank you, and over to you, Melody.
Thank you so much, everyone. Thank you, Nalima. Thank you, everyone, for your insight and for staying with us throughout this session. And thank you for your key contributions, Advocate Aroka, Okwara Masafu, and of course, Kelly. Thank you so much for those beautiful insights. Allow me to, just a minute. Allow me to one, extend also gratitude to those that we involved during this research, starting with the National Gay Lesbian Human Rights Commission, where Advocate Okwara Masafu works, Mwamko Mpya, Amkeni Malindi, Hapa Kenya, CAC Church, Intersex Initiative Course, that is IRIC, International Care for Reproductive Health, ICRH Kenya, PEMA Kenya, Center for Minority Rights Strategic Litigation, Rainbow Women of Kenya, Coast Women for Women, Upinde Advocates for Inclusion, WAFI, GAC Plus, Watu Center for Health and Advocacy, Wacha Health, Queer Women Human Rights Defenders, Jinsi Yangu, Lake Region Women Health and Equal Rights, CBO, that is Lare, Elite LBQ, and anybody else who is also a human rights defender and works for civil society, because also as an individual who has contributed their time, expertise, and any personal data and narratives that have contributed to this. We also wish to thank the National Police Service, particularly Nyali, Bamburi, and Likoni police stations for their contribution and a realization of this report, and anybody else who individually contributed to this report. Thank you. Then at the end of this all, I wish also to welcome you to scan the QR code and join the conversations that are continuing to happen. That is using the hashtag behind the badge, hashtag the issue is violence. Kindly scan the QR code on your screen and download the report. And also I have shared several times the links on the chat. If you could kindly also look at the report down there and join the conversations and demand for accountability, demand for change, because change starts with you. For your voice really matters in engagement with law enforcement and our human rights. As you scan the QR code, kindly, I will also wish to remind you that this webinar will be posted on YouTube, which I will share. So kindly do follow the hashtag behind the badge so that you can also revert and come back to get the much insights that are being shared. So take a minute, scan the QR code. And thank you everyone for joining us and for those who have stayed. Have a lovely end of the week. Since today is Thursday, have a lovely end of the week.
Thank you. Bye.
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 Nice lunch.